Hello friends, today I have taken up a new subject Bhartiya Nagrik Suraksha Sanhita BNSS 2023. So I have selected some important questions which are generally asked in the university exams. Hope you will find very good this question. So let me start. Question number 1. Discuss the power of magistrate for maintenance of public order and tranquility. The answer will be powers of magistrate under BNSS, that is Bhartiya Nagrik Suraksha Sanhita. It empowers executive magistrates to act decisively in situations threatening public peace. Number 1. Dispersal of unlawful assemblies, which comes under Section 148 to 151. Magistrates can order dispersal of assemblies of 5 or more persons likely to disturb peace. Second is, if the crowd refuses, they may use civil force, arrest participants, or seek police assistance. In extreme cases, they can requisition armed forces to restore order. Now, second is preventive measures. Section 152 to 157. Magistrates can issue directions to prevent public nuisance or potential disturbances. They may restrict certain activities, that is, blocking of roads, loud gatherings, to ensure tranquility. Third is special restrictions, which comes under Section 163, allows temporary prohibitory orders similar to curfew or Section 144 under CRPC, Criminal Procedure Code, applied when there is imminent danger to public peace or safety. What are the objectives of this? To ensure immediate control over volatile situations, to protect citizens' liberty by guaranteeing a peaceful environment free from fear. So, VNS 2023 strengthens the role of magistrates as guardians of peace. They act strictly against unlawful assemblies, impose preventive restrictions, and ensure that public life continues without disturbance. Now, question number 2. Discuss the power of criminal courts. So, answer will be under the Bhartiya Nagrik Suraksha Sanhita, under Chapter 3rd, Section 21 to 29 define the power of criminal courts. Number 1, High Court comes under Section 22. It can try any offence. It may pass any sentence authorized by law, including death penalty, but death sentence must be confirmed by the High Court itself. Second is Court of Session, Section 22. It can try serious offences, may impose any sentence except death penalty or life imprisonment unless confirmed by the High Court. Session judge and additional session judge have the similar powers. Chief Judicial Magistrate, insert CJM, it comes under Section 23. He can impose imprisonment up to 7 years. He may levy fines as prescribed. Magistrate of first class, Section 23. He can impose imprisonment up to 3 years and can fine up to 50,000. Magistrate of second class, it also comes under Section 23. He can impose imprisonment up to 1 year or fine up to 10,000. Other provisions come under Section 24 to 29. Courts can impose imprisonment in default of payment of fine. They can award sentences for multiple offences in one trial. Powers may be exercised by successors if a judge or magistrate is transferred. Community service may be ordered as an alternative punishment. Now question 3. Define search. Discuss the law relating to search and seizure as prescribed under BNS 2023. The answer will be under the Bhartiya Nagrik Suraksha Sanhita BNSS. Search means examining a person, place, or property to find evidence, while seizure means taking possession of such evidence. BNSS Section 44 10224 lay down detailed rules for lawful searches and seizures, ensuring they are conducted with proper authority, safeguards, and respect for individual rights. Now, relevant provisions. Section 44 BNSS. Police officers may conduct searches when authorized, especially in case involving suspicion of crime. Now, Section 102 to 104 BNSS. Section 102. Police can seize property suspected to be stolen or linked to an offence. Section 103. Searches must be conducted in the presence of independent witnesses, punches, and the list of seized items must be prepared and signed. Section 104. Magistrate can issue such warrants when necessary, ensuring judicial oversight. Now, what are the safeguards for this kind of search and seizure? Searches must respect constitutional rights. Article 19.5. Property rights are not absolute. Independent witnesses ensure transparency. Detailed records of such items prevent misuse. There is a case law in D.K. Basu versus State of West Bengal, and similarly State of Punjab versus Balbir Singh emphasize protection against arbitrary searches. So these searches must not be arbitrary. Now question 4. Under what circumstances police can arrest without warrant? Explain it. The answer will be circumstances of arrest without warrant. Number 1. Cognizable offences. It comes under section 35 of BNSS. Police may arrest without warrant if a person is suspected of committing a cognizable offence, serious crime such as murder, rape, kidnapping and robbery. Cognizable offences allow police to act immediately without prior approval of a magistrate. Second is refusal to give identity, section 39 BNSS. If a person refuses to provide their name and residence when demanded by police or give false information, they can be arrested. This happens in the case of non-cognizable offense. Preventive arrest. Section 170 BNSS. Police may arrest to prevent the commission of a crime if they reasonably believe someone is about to commit an offence. Proclaimed offenders. If a person is declared a proclaimed offender by the court, police can arrest them without warrant. Other situation, if a person is in possession of stolen property, if a person obstructs police in execution of duty, if a person is involved in offences against public order or safety. Now question 5. What do you mean by investigation of crime? How does a police officer investigate a offence of murder? Discuss in the light of relevant provisions of BNSS. Investigation of crime under Bhartiya Nagrik Suraksha Sanhita means the process by which police collects evidences, identifies suspects, and build a case for trial. Investigation is defined as the process carried out by police officers to detect crime, collect evidence, identify offenders, and present findings before the court. It begins after the registration of a first information report (FIR) and continues until the filing of a charge sheet. Now, registration FIR comes under section 173 of BNSS. Police must record information about a cognizable offence like murder. Crime scene examination. Officers visit the scene, secure it, and collect physical evidence, blood stains, weapons, fingerprints, etc. Collection of evidence come section 179 to 184. Statements of witnesses are recorded. Forensic and medical examination of the body is conducted. Digital evidence such as CCTV call record is gathered. Fourth is arrest of suspects, comes under section 35 to 39 of BNSS. Police may arrest without warrant in cognizable offence like murder. Custodial interrogation and remand which comes under section 187. Suspects may be interrogated and police can seek remand from magistrate. Post-mortem examination conducted by medical experts to determine cause of death. Filing of charge sheet. Section 193 of BNSS. After investigation, police submits a report to magistrate with evidence and witness statements. Now question 6. When can a court issue warrant to compel the appearance of a person? The answer will be the Bhartiya Nagrik Suraksha Sanhita lays down the rules for issuing warrants and summons from section 90 to 93. The court can issue a warrant when it believes that a person's presence cannot be ensured merely through a summons if or the person does not appear despite receiving the summons. Now, key sections related to warrants in BNSS 2023. Section 90. Issue of warrant in lieu of or in addition to summons. The court may issue a warrant in lieu of or in addition to summons. This is done only if the court believes that the person will not comply with the summons or will remain absent. Section 91. Powers to take bond for appearance. This section outlines the court's power to require a person to furnish a bond with or without sureties to ensure their appearance in the court. Arrest. Section 92. Arrest on breach of bond for appearance. Section 93. Provisions under this section generally applicable to summons and warrants of arrest issued by the court. Now there are two types of warrants also, bailable warrant and non-bailable warrant. Now bailable warrant. In this, the accused can be released on bail if the accused provides sufficient surety for his court appearance. Non-bailable warrant, in this case, this is a serious case, the accused is arrested and brought before a judge to apply for a bail. Now question 7. When does the court issue a summons and a warrant to an accused? What is the procedure for first appearance of the accused in court after arrest under BNSS? If the court believes the accused will appear voluntarily, it issues a summons. If the court is convinced the accused will not comply with the summons or may abscond, then it issues a warrant. Under section 90 of BNSS, the court may issue a warrant instead of or in addition to summons. After arrest, the accused must be produced before a magistrate within 24 hours. The magistrate examines whether the arrest is lawful and decides the next step. In serious cases, the accused may be sent to judicial custody or police custody. This procedure is provided under section 57 and 58 of BNSS. Now question 8, and this is the last question I think. Under what conditions is the executive magistrate authorized to exercise powers under section 163 of BNSS? The answer will be section 163 of BNS empowers an executive magistrate to issue orders in urgent situations where immediate prevention or quick remedy is required to avoid danger, nuisance, or disturbance to public peace and safety. Circumstances under which the magistrate is authorized. Number 1. Reasonable satisfaction. The district magistrate, sub-divisional magistrate, or any specially empowered executive magistrate must be satisfied that there is an emergency requiring immediate action. Second, public nuisance or threat. When an act, event, or situation creates or is likely to create public nuisance, danger to human life, health, or safety, disturbance of public tranquility, risk of riot or affray. In these conditions, this power can be executed by the magistrate, executive magistrate. Now, third is immediate prevention needed. If waiting for a regular inquiry or hearing would worsen the situation, the magistrate can act instantly. Written order. The order must be in writing, stating the material facts of the case. It can direct individuals, groups, or the public at large to abstain from a certain act or take specific measures. Temporary nature. Such orders are temporary and preventive. not permanent solutions. They can later be modified, rescinded, or replaced after hearing the parties involved. Now, what is the practical importance of this 163 section? Section 163 is a preventive tool for law and order. It allows quick intervention in emergencies, like a collapsing building that threatens lives, violent clashes about to erupt, hazardous industrial leakage, unlawful assembly that may disturb peace. So, this is all about the important questions of BNSS. So, please do memorize these questions. Thanks for watching this video.